My dear students, welcome to the new class, 9th semester. Welcome to James. I'll be taking drafting of pleadings and conveyancing paper for you. So today we are going to start our first lecture. That is a background lecture prepared especially for you, so that you may be aware what is drafting of pleadings and drafting of various deeds for conveying various rights. This background lecture and this photograph is depicting you the job of a legal potter. You see in this diagram, in this picture, this old man is preparing pots from clay. So whenever a client comes to you, he gives you raw facts in the shape of ordinary clay. Now you are supposed to remodel this clay into the shape of a pot. Likewise, you are supposed to read the raw facts given to you by your client, and then out of those raw facts, you will draft either a plaint or written statement, as the case may be, or a deed of gift, deed of sale, as the case may be. Again, you see, the process of drafting is in progress. Since a lawyer is a legal potter, this diagram shows that clay is taking shape. So raw facts are taking shape of a pot in this diagram. Now this third diagram shows you that clay or the facts are in the process of molding, and lawyer is also in the process of thinking, and rough draft is ready. You can take printout of this rough draft also. Then finally, clay is converted into a pot. Likewise, raw facts are converted into a plaint or written statement or a deed to convey the rights. And this picture shows that plaint or WS or the deed which you wanted to draft is ready. And this diagram also shows that drafting process is now over. So my dear students, this is the job of a lawyer. I have equated the job of a lawyer with the job of a potter. Potter prepares the pot from ordinary clay, and a lawyer prepares the deed. Lawyer prepares the plaint or written statement out of raw facts given by your client. Here is a book placed before you for drafting and reading. You can pick up any one of these books, or you can connect yourself with internet also. So now I'm taking one illustration, the question number 1, that is draft a plaint in a case of specific performance of a contract. And all the effects of this case will be imaginary. Dear students, please note down this illustration. With the help of this single illustration, I will cover half of the syllabus of drafting and pleading. So you must remember these facts by heart so that the subsequent drafting becomes easier for you. And the facts are very simple, that X agreed to sell his flat number 906, Designers Park, Sector 62, Noida, Gautam Buddha Nagar, for a sum of rupees 1 crore on 1st January 2017. He received a sum of rupees 10 lakh as advance money, and this agreement was duly registered in the office of Sub-Registrar, Noida. The final sale deed was to be executed within 6 months from the date of agreement. A requested X so many times to execute the sale deed in his favor orally on mobile, and also sent him 3 emails also. But he kept on giving false promises. Thereafter, A served a notice dated 5th June 2017 to X by registered AD post for execution of sale deed on 20th June. But X did not turn up for execution of the sale deed in the office of sub-registrar on due date, that is 20th June. A further notice dated 21st June 2017 was sent to X by registered AD post for execution of sale deed on 30th June. But still he did not turn up for execution of the sale deed. Now, A, the purchaser, wants to file a suit for specific performance of the contract under specific relief act. Now, as a lawyer, you are to advise your client what to do. With these facts, my dear students, we will start learning the process of drafting of pleadings, that is, drafting of plain and written statement. This background lecture is meant to tell you few provisions of CPC also. You know, unless you know the law beforehand, you cannot apply it while drafting. So, first of all, what is pleading? Pleading shall mean plain and written statement according to Order 6, Rule 1 of CPC. My dear students, I'll advise you to keep bare act of Code of Civil Procedure with you when you are learning the process of drafting, because lot many orders, rules and sections of CPC will be involved when you learn the process of drafting. So what are pleadings? Simple meaning of pleading is plain and written statement. And pleadings are statement of facts in writing drawn up and filed in a court by each party to a case, stating therein what his contentions shall be at the trial, and giving all such details as his opponent will need to know in order to prepare his case in his answer. The present day system of pleading is based upon provisions of CPC. Hence, I request you to please keep bare act of CPC with you. Now, drafting of plain. What is a plain? What is the definition of a plain? You should know it. According to P.C. Monga, very famous book, a plain is a legal document of plaintiff containing a statement of claims and setting his cause of action with necessary particulars, which is sent to other party, opposite party, defendant, to confirm or to rebut the action to be taken against him, and to submit his version in the form of a written statement. So this is the definition of plain. And what is definition of written statement? A statement of defenses called WS in short, or written statement, in which defendant deals with every material fact alleged by the plaintiff in the plaint, and also states any new facts which fall in his favor. Replication. What is replication? Replication means mentioning any ground of defense which has arisen after institution of suit or presentation of WS may be raised by the plaintiff or by the defendant in his written statement. These subsequent pleadings are normally called as replication of plaintiff and additional WS of the defendant. My dear students, please note legally, replication is not part of pleading. Replication may work as the clarification of certain points which are already taken up in the plaint, but they are not part of pleadings. So far as the drafting of pleading and convenience deed is concerned, the first and foremost point while drafting a plaint or WS, presently I am talking about drafting of plaint and WS. We'll take up the drafting of deeds later on in subsequent lectures. So the first item to be drafted is the name of the court. And how do you come to know the name of the court? Because hierarchy of civil courts, hierarchy of criminal courts starts from Supreme Court down to the junior-most court in a district. And you know the law, section 15 of CPC says that every suit shall be instituted by presenting a plaint in duplicate in the proper court of lowest grade, competent to try it in accordance with law. And every plaint should comply with the rules contained in Order 6 and 7. A written statement should comply with the rules contained in Order 8. So the suit has to be drafted for institution in the proper court of lowest grade, competent to try the suit in accordance with law. So the name of the court which you will draft, that should be the court of lowest grade, competent to try it. Then pleadings should contain the facts and not the law. There are certain fundamental rules for drafting of plaint and WS. And the first and most important rule of drafting is that your pleading should contain facts and not the law. You cannot write legal arguments in your plaint. But foreign laws are equivalent to facts. If you are quoting some foreign legislation, then that foreign legislation has to be pleaded as a fact. And then mixed question of fact and law can be pleaded. Like you are saying in your WS, that suit of the plaintiff is barred by limitation. So this is a mixed question of fact and law. That should be stated in written statement. And the pleadings are to state only material facts and material facts only. As a legal quarter, you will draft only material facts. The entire story told by you, by your client, need not be pleaded in the plaint or written statement. So only material facts. Material facts are the date of agreement. Material facts are the value of the property, 1 crore. Advance money, 10 lakh rupees. Period of sale deed, 6 months. These are the material facts. Then refusal by the defendant. Then sending of legal notice are the material facts. And dear students, the next rule of pleading is that you should state the facts and not the evidence. This is the mandate of Order 6, Rule 2 CPC, that you are to draft facts of the case and not the evidence. Because evidence has to be produced in the court later on. So state your material facts concisely, with precision and certainty. And all these facts are to be divided into paragraphs to be numbered consecutively. And while drafting, the date, sums, and numbers shall be expressed in figures as well as in words. Like sum of rupees 1 crore. This has to be expressed in figures as well as in words. Flat number 906, designer's part. So 906 has to be mentioned in figures as well as in words. Then dear students, you will see that forms of pleadings are given in Appendix A to CPC. The thick bare act of CPC, the last portion is Appendix A, in which all forms of pleadings are being mentioned. The form of plaint, form of WS, form of notice. All these pro formas or formats are given in the appendix. And then the next rule, my dear students, is that if you want to plead particulars of misrepresentation, fraud, breach of trust, undue influence, then they must be pleaded in your pleadings. Suppose the builder says that the agreement dated 1/1/2017 was result of undue influence. The plaintiff had put a pistol on the head of the builder and got the agreement executed. So this spectrum of undue influence must be pleaded in your WS. This is the mandate of Order 6, Rule 4, CPC. And if there is some condition precedent, advance condition, so that condition precedent should also be pleaded. For example, if you are going to file a suit against Government of India, so legally you are supposed to give a notice under Section 80 CPC. Or if a landlord is filing a suit of ejectment against the tenant, then he is legally required to issue a notice terminating the tenancy of the tenant under Section 107 of TP Act. So giving of notice, Section 80 CPC or 107 TP Act has to be pleaded in the plaint as a fact. In one of the paragraph, you will write that a notice under Section 80 CPC has been duly served upon the central government. Or in a case of rent ejectment, you will plead in one of the paragraphs in the plaint that a notice under Section 107 of Transfer of Property Act has been given to the tenant. And you should take this care that whatever you have written in the pleadings, either in the plaint or in the WS, it is fine. No departure from original pleading is allowed except by way of amendment. Of course, you can move an amendment application under Order 6, Rule 7. But otherwise, you are not allowed to depart from your pleading. So you must be very, very careful while drafting your plaint and WS. And the effects of documents. Your document illustration I have given is agreement to sell. So what is the effect of that document, agreement to sell, has to be stated and mentioned in your pleadings. You will briefly mention the effect of the document, that sale deed was to be executed within 6 months and the builder has failed to execute the sale deed. So briefly, the effect of document has to be pleaded in your plaint or WS as the case may be. And as I told you, the effectum of malice, knowledge, fraudulent intention should also be clearly pleaded in your pleadings. The notice I told you, any kind of notice which you have given to the defendant before filing a suit, so that factum of notice given to the defendant should be pleaded in the plaint. This is the mandate of Order 6, Rule 11 of CPC. And if there is any implied contract, that should also be pleaded in the plaint. Suppose between builder and seller, between seller and purchaser, there is a condition that if purchaser fails to pay the balance money and get his sale deed executed, then he will forfeit his earnest money. And if the builder fails to execute the sale deed in time, then he will have to return double the amount of the earnest money. So if this is an implied contract, this was an implied contract, not written in the agreement dated 1/1/2017, then this implied contract has to be pleaded in the plaint. And presumptions of law, as I told you, neither law is to be pleaded, nor the presumptions of law in favor of a party are to be pleaded. They need not be pleaded. Suppose you are filing a case of recovery of money based upon check which was dishonored. So there is a presumption in favor of the party that check was issued for a valid consideration. So this paragraph relating to consideration of bill of exchange, where plaintiffs use only on the bill and not on the consideration as a substantive ground of claim. So this presumption of law in favor of a party need not be pleaded. Neither law is to be pleaded, nor the presumption of law is to be pleaded. These are the fundamental rules which you must take care before you start drafting of pleadings. Now, the pleadings are to be signed by respective parties and their pleaders. Of course, plaintiff and his counsel will sign the plaint, defendant and his counsel will sign the WS, and this is the mandate of Order 6, Rule 14 CPC. If plaintiff is not available for signing the plaint, the power of attorney holder may sign the plaint on behalf of plaintiff. Likewise, the power of attorney holder of the defendant may sign the plaint on behalf of defendant. And when a suit is filed on behalf of minor or lunatics, then of course guardian will sign the plaint or written statement, as the case may be, on behalf of minor or lunatic. Then at the foot of the plaint, verification is an important clause that you will have to take care. Every pleading is to be verified at the foot by plaintiff or defendant, as the case may be, or by one of the parties pleading, or by some other person proved to the satisfaction of the court to be acquainted with the facts of the case. It's not necessary that plaintiff himself knows all the facts. Maybe that clerk or munshi on behalf of plaintiff, or the landlord who collects the rent on behalf of the owner of the property. He may be a better person. He may be having knowledge of all the facts instead of the owner. So if there is such a person who is acquainted with the facts of the case, he may also sign the plaint. The best example is the munshi or the clerk working on behalf of Sethji, a very rich person. He has so many properties. So his munshi or clerk is collecting the rent. He knows the facts of the case better than the rich man. So this is part of pleading, that verification has to be done by the parties. And this verification is to be done by para number wise. The party verifying the pleadings shall specify by reference to be numbered paragraphs of the pleadings, which he verifies of his own knowledge, and what he verifies upon the information received. From where the information is received by the party? The information is received from his advocate or other sources. But that advice has to be believed by him to be true. And this is the mandate of Order 6, Rule 15 of CPC. That how many paragraphs of the plaint are true to the personal knowledge of the plaintiff, and how many paragraphs are true to his knowledge on account of legal advice received by him from an advocate, which all he believes to be true. So my dear students, these are few fundamental directions or the rules which you must keep in mind before you start drafting of pleadings. Now, part of this lecture is a model plaint structure. Of course, we will begin with the example of filing a plaint in case of specific performance of a contract. The illustration, the facts which I gave you in the beginning of this lecture. So all these facts, you see, if there is a question in the examination that draft a plaint on behalf of purchaser against the builder for specific performance of the contract and no other facts are given in the question paper, then you are to presume facts at your own unless they are given in the question paper. The question paper cannot be so long. You will find question one-liner or two-liner. So the facts which I gave you, if you remember those facts, very easily you can draft a plaint. So dear students, drafting is a game of imagination. You have to imagine your own facts. You have to assume your own facts because question paper does not contain the facts on the basis of which a plaint is drafted. So you will have to keep in mind that every plaint contains the fundamentals of the plaint. And the initial question which I gave you in the beginning is where to file the plaint. Plaint has to be filed according to the jurisdiction. You will find out the name of the court according to the jurisdiction allotted to the court. And if you will read section 15, 16, 17, 18, 19 and 20 of CPC, you will come to know which court has jurisdiction to hear your matter. And for this, dear students, you must have the knowledge of hierarchy of courts in India. If you are drafting a plaint, you should have the knowledge of hierarchy of civil courts in India. And if you are drafting a criminal complaint or application for bail on behalf of the detainees, then you must have the knowledge of hierarchy of criminal courts in India. So here is a diagram before you, which gives you at a glance the knowledge about the various courts which are working in India. And on the top of it, you know, Supreme Court of India is there with some original, appellate and writ jurisdiction, including the jurisdiction to hear special leave petition. And next, lower court after Supreme Court is the High Court in the state. High Court also has appellate jurisdiction, revisional jurisdiction, and writ jurisdiction. Coming down, we have the courts of district judges and additional district judges. This is an example of UP. So district judges and additional district judges can hear appeal up to valuation of 25 lakhs and revisions up to valuation of 5 lakhs. This 25 lakh and 5 lakh means the valuation of the suit which was given in the plaint. Coming down, we have the Court of Civil Judge Senior Division. That is a parent court having experience of more than 3 years of service. They have unlimited jurisdiction. Original jurisdiction is above 5 lakh. Because up to 5 lakhs, Civil Judge Junior Division is the court which is authorized to hear cases relating to valuation up to 5 lakhs. So illustration which I gave you, the valuation of the flat was 1 crore rupees. So that suit for specific performance has to be filed in the Court of Civil Judge Senior Division. Because Civil Judge Junior Division has jurisdiction to hear suits only up to 5 lakh. Then we have additional civil judges. They have the power to hear original suits up to rupees 1 lakh. Certain civil judges are given powers of judge small causes. They are known as JSCC, Judge Small Causes Court, under Small Causes Courts Act 1887. Like case of rent and ejectment is to be filed in the court of Judge Small Causes. So the valuation of a CC suit up to 1 lakh is to be heard by civil judge, junior division. And in money suits, the jurisdiction is different. Court is same, judge small causes. But the jurisdiction is money suits up to 25,000 rupees. Money suits means a suit relating to recovery of money. Now, dear students, all these civil courts, which I have shown you from Supreme Court to Civil Judge Junior Division, all these courts are actually one if appeal goes to the Supreme Court. And the powers, so far as the powers are concerned, the judge of the appellate court steps into the shoes of a trial judge. And the corollary is that a judge of the appellate court cannot exercise more powers than that of trial of the than that power of a trial judge while sitting as an appellate judge. The equation is power of appellate court are equivalent to the power of a trial judge. This is the mandate of section 107 clause 2 of CPC. Likewise, on criminal side, if you see the last proviso of section 386, it says that appellate court, while sitting in appeal, cannot award more punishment than what could have been imposed by the trial judge. Now let us see and have a glance upon the hierarchy of criminal courts in India also. Top of it, sentence. Top of it, the court is Supreme Court of India, and they are authorized to pass any sentence authorized by law. Then High Court in the state also authorized to pass any sentence authorized by law. Then we have the courts of district and sessions judges, oblique additional district and session judges. So district and session judges, a post from which I retired, I superannuated. I was authorized to pass any sentence authorized by law, but death penalty is subject to confirmation by the High Court. As a district judge, I cannot impose a final death penalty. I can award death penalty, but file has to be sent to the High Court for its confirmation, for the confirmation of the death penalty in accordance with section 366 of CR. Then we have the courts of assistant session judges. They are authorized to award 10 years imprisonment or fine or both. Then we have court of CJM and ACJMs. They are empowered to impose a fine of 7 years, imprisonment up to 7 years, or fine or both. Then we have the Court of Judicial Magistrate Class 1. In Delhi, we call it Metropolitan Magistrate. They are authorized to impose a sentence up to 3 years or fine up to 10,000 rupees or both. And last court on criminal side is Judicial Magistrate Class 2. They are authorized to impose a sentence up to 1 year or fine up to 5,000 rupees or more. So this is a chart summary before you so far as hierarchy of criminal court systems. And all, again, as I told you on the civil side, likewise on the criminal side also, all these criminal courts are actually one if appeal goes up to Supreme Court. And judge of appellate court steps into the shoes of a trial judge, meaning thereby the judge of appellate court cannot exercise more powers than that of a trial judge while sitting as appellate judge. So the equation is the same again. Power of appellate court are equivalent to power of a trial judge. Then, dear students, you must know that if appeal is going up to Supreme Court, case has passed through 4 stages. The suit was filed in the Court of Civil Judge Junior Division or Senior Division. First appeal was filed in the Court of District Judge. Second appeal was filed in the High Court. And lastly, the party went to the Supreme Court. So you have 4 judgments before you. So which judgment will prevail? The doctrine of merger says that all these 4 judgments will merge into one, and whatever is decided by the Supreme Court or the final court will be executed. This doctrine of merger is neither a doctrine of constitutional law nor a doctrine statutorily recognized. It is a common law doctrine founded on the principle of propriety in the hierarchy of justice delivery system. And the logic underlying the doctrine of merger is that there cannot be more than one decree or operative order governing the same subject matter at a given point of time. Once the Superior Court has disposed of a list or a case before it, either way, whether the decree or order under appeal is set aside or modified or simply confirmed, then it is the decree or order of the Superior Court which is final, binding, and operative. So all the judgments will merge into one, all the decrees will merge into one. And what merges is the operative part of the order. Entire judgment is not going to merge. It is the operative order passed by the highest court will prevail. So what merges is the operative part of the order, that is the mandate or decree issued by the court, which may have been expressed in positive or negative. And you know, a decree as defined in section 2 clause 2 of CPC would be enforceable irrespective of the fact whether it is passed by the trial court or by the first appellate court or by the second appellate court or by the Supreme Court. Why? The reason is highlighted here. Statutory appeal is nothing but confirmation of the suit. I am repeating. Statutory appeal is nothing but continuation of the suit. Mere filing of appeal does not operate as a stay of the decree of the lower court. The decree cannot be executed if the stay order is passed by the appellate court. Finally, the decree of lower court merges with the decree of appellate court, and decree of appellate court supersedes the decree of the lower court. And to doctrine of merge means to sink or to disappear in something else, or to become absorbed or extinguished, or to be combined or to be swallowed up. So merger in law is defined as absorption of a thing of a lesser importance by a greater, whereby the lesser ceases to exist, but greater is not increased. So the decree of the lower court loses its identity, and individually it is lost, it is merged in the presence of decree of the superior court. I'm giving you an example before I close this lecture. If I win the case from all the 4 courts of the Supreme Court, can I have 4 sale deeds of 4 flats in my favor on the basis of single agreement? Probably your answer will be no. If I have won my case from 4 courts, I am entitled to execution of sale deed in my favor only once, on the basis of my original agreement dated 1/1/2017. So this is, dear students, the doctrine of merger. So why I gave you this idea? You are supposed to draft pleading at every stage. You will file suit in the Court of Civil Judge Junior Division or Senior Division. And if you are to file appeal, appeal has to be redrafted. If you are going again in the High Court, second appeal is to be drafted. If you are going in the Supreme Court, again SLP is to be drafted. So drafting has to be done at each and every stage. But the decree and judgment passed by the highest court will prevail. So dear students, thank you very much. This is lecture number 1 for you relating to drafting and pleading. God bless you.